Welcome back everybody to our studies in jurisprudence. In this lesson we are moving on to topic number 5, which is going to be the first topic of our members only content. This video will be a free video to give you a bit of a basic overview of what we're going to be talking about. And in topic number 5 we're going to be talking broadly about feminist theories of law. Now, obviously, feminism involves the rights of women, generally speaking, and as you can sort of hear in my voice, I'm not one of, I'm not a woman. I'm not one of those people. So I'm going to try and do this and approach this topic from a perspective of extreme objectivity and neutrality, and just sort of present the kind of theories that are presented in relation to jurisprudence, without necessarily going into any kind of difficult exegesis of each of these texts or anything like that, just so that you get an overview of what feminist theories of law essentially represent and are represented by. So this lesson is going to be something of an introduction to this particular topic. We'll be thinking about the idea of feminist theories of law from a quite broad and foundational perspective in this video, essentially thinking about how law is framed, how law is viewed, and how law is understood from this kind of perspective, and the ways in which this kind of perspective challenges the traditional perspectives of law that you might find when thinking about ideas related to positivism or natural law theories, for example. So feminist jurisprudence, or feminist philosophy of law, as you can probably think and probably imagine, is an approach to legal theory that critically examines the way in which the law and the structure of law and the framing and systemic nature of law has contributed to feminist issues, specifically, of course, to the oppression and subordination of women, as well as how it perpetuates broader gender inequalities. So it looks to examine through the lens of a feminist perspective the approaches that law has essentially taken when it comes to things like oppression and subordination and the perpetuation of gender inequality. Now, of course, just like with any jurisprudential theory, just like with any theory of law that is either a positivist, a natural law theory, maybe Marxist or anarchist theories of laws, you obviously have to think about the fact that there are lots of varying degrees of agreement and disagreement among even these subcategories. So not all feminist jurisprudential scholar agrees with every other feminist jurisprudential scholar. Some argue that the law simply perpetuates oppression in terms of the substance that is passed. Some argue that the way in which the law is fundamentally structured is one that's always going to perpetuate gender inequalities. So obviously you have various ranges of views when it comes to this kind of topic. It challenges the traditional legal frameworks that have been essentially claiming that the law is neutral. Okay, so one of the basic ideas that you might find when thinking about positivist or natural law theories, or even social theories of law, to a lesser extent social theories of law, but to these kinds of ideas of law, is that, well, law is essentially just a neutral framework from which rules are developed or ideas are developed, however you want to frame and understand law. But the sort of key characteristic for most non-feminist approaches is that when it comes to gender, or when it comes to sex, and when it comes to the distinction between men and women, the law is silent on this issue. The law is basically neutral. The feminist jurisprudential scholar would challenge that narrative and argue that instead, in practice, law may be shaped by patriarchal structures, and that it's these kinds of structures that will often disadvantage women. Now, in addition to this, a number of feminist scholars, of course, are a little bit more inclusive than that, and will say, well, not only women, but it will disadvantage other marginalized groups. And this kind of framework essentially is one that would not benefit in any meaningful way these kinds of marginalized groups, including women. And so a feminist legal scholar argues that laws are designed in the past, or they have been designed, or they are designed in the future, interpreted and applied in all the different ways which will reflect and sustain patriarchal power dynamics. And this is, of course, a problematic issue. Feminist philosophy of law not only looks to try and identify these areas where there is a clear inequality, where there is a clear imbalance, either in the design, interpretation, or application of law, but also to critique these power imbalances and to try and think of ways in which we can reformulate basic principles of law and practices to achieve what could be described as gender justice or gender equality, or just general parity between men and women in relation to the way in which law upholds these structures. With that in mind, then, one of the things that you would probably have come to the conclusion of already is the rejection of the idea that law is necessarily objective. So, one of the central arguments of a feminist legal theory is a critique of the supposed and the alleged neutrality and objectivity of law. Instead, feminist theories assert that legal systems, while they may claim to be neutral, they may even look like they're neutral on their face, are actually built on patriarchal, male-centered experiences and values. And so the result of this is, because they are built on these experiences and values, and they're sort of built with this particular group of people in mind, the result of that, the sort of end result of those laws being implemented and applied and interpreted, leads to often marginalizing or excluding women's perspectives on the law in this regard. Laws that claim to be neutral will often overlook the specific ways in which they disadvantage women. And this may not necessarily even be a deliberate sort of misogynistic approach where they are deliberately marginalizing women as a result. But that's not the point here. The fact is that this is a systemic inequality. The idea being that it doesn't have to be the case that every single person who is male working in law are necessarily sexist or misogynistic. It's the fact that because there is this lack of value that is seen when we think about the perspectives of women or other people of marginalized groups, this leads to results that disadvantage those marginalized groups or women, regardless of whether or not there was an intent for there to be this disadvantage in the first place. So this is one of the things that is often seen as a difficult thing for some people to get their heads around, but generally speaking, the same can be said when we think about theories relating to race and systemic racism. The idea of systemic racism does not necessarily imply that every single person working in that particular system that is being accused of systemic racism is necessarily an ardent racist. That's not the point. The point is that the kind of slight biases or the way, or historically the way a system is established, or past historical racisms that did exist, have led to a situation where there is a disadvantage among one group over another, and that over time and sort of in the aggregate you start to see these disadvantages and you start to see this disparity in terms of perspective. The same can be said about the feminist critique of law and its supposed objectivity. So, for example, if an employment law fails to accommodate basic pregnancy or caregiving responsibilities, when we think about the treating of male versus female workers as though they have the same life experience, this would obviously, in reality, disproportionately harm women. And so this is an example where you might find yourself applying the law prima facie in a neutral way. You might go, well, the law is being applied neutrally, it's being applied equally to men and women in that regard. But to do that would be to fail to recognize the disproportionate experience of, for example, pregnancy between men and women. Men have a different experience of pregnancy than women. Women have a far more, let's just say, hands-on, involved, and quite substantial approach when it comes to pregnancy compared to that of, or experience, should I say, compared to that of men. So even a seemingly objective application of the law in that kind of regard would necessarily disproportionately disadvantage women over men, because seeing those two individuals as equal in that kind of area of policy is, while on its face and on paper an objective and neutral application of the law, in fact results in a disadvantage. Finally, then, oopsie daisy. Finally, then, when we think about this idea of the law, many legal principles in this kind of idea is framed as universal. So there's this sort of equal application that is applied to everybody, and so we sort of, as individuals who follow the law and who think about the law and sort of philosophize about the law, might sort of give that a big tick and say, look, we have applied the law equally to everybody. There's no more problems to be had. Let's just move on to the next issue, for example. This would, of course, overlook quite a significant concern, because what this does is tend to reflect the experience of privileged groups. So I've written in brackets here, often men, often specifically white, often heterosexual, often middle to upper class, and I'm sort of just defining the characteristic of the person in society that's historically had the most influence and power in these different kinds of areas, especially when it comes to things like lawmaking, the judiciary, parliament, all of these different areas where law is made and interpreted and applied. Historically was almost exclusively the remit of specifically white, often heterosexual, often middle to upper class men. And so these kinds of groups would have a benefit that would get carried down through historical injustices that would often lead to experiences of privileged groups not being, or the experience of privileged groups being essentially prioritized, not even necessarily intentionally, but just prioritized over that of the experiences of less privileged groups, maybe people who have experiences on the basis of gender, maybe women or people of other gender expressions. What about people who are non-white, for example? What about people who are LGBT? What about people who are working class and are often marginalized as a result of the fact that their educational attainment is not as high as others? What about the interaction of all of these different things, a theory known as intersectionalism that we're going to look at in future lessons? All of this is, of course, something that we're going to have to think about in more detail, and that we're going to apply when we start to look at different theories of law from a feminist perspective over the next few lessons.